The next section of bills, we're going to look at our judicial administration. Now, these are the bills that are probably going to have the biggest impact on the day-to-day operations of courts in the state.
The advisory commission, John, you list here, this was a committee that had been very inactive and then was active for the last several sessions. It looks like it will be fairly active again. We haven't seen the agenda yet, but it'll be something that we can participate in and hopefully have some effect. This is an area where possibly, if the courts are seeing a real adverse effect on the pre-sentence investigation report situation, that it could be addressed there.
And a couple things that the Advisory Commission will be looking at related to some bills that passed. They'll be studying the idea of civilly committing sex offenders, and they'll be reviewing law enforcement policies and procedures related to eyewitness identification pursuant to Assembly Bill 107. So you can go ahead and take a look at that. That is in this review manual.
A lot of these measures were, again, you can almost shake your head, but then some newer legislators had some real strong feelings about some of these issues, and that's how some of this came into being. So we'll see how that develops.
AB 7, this was one of the 6 bills advanced by the Judicial Council and the Judiciary, and this bill expands the time a district court judge has to reply to an affidavit to disqualify from 2 calendar days to 5 judicial days. So that gives district judges quite a bit more breathing room and maybe a little bit more reasonable amount of time to reply to those affidavits. Assembly Bill 156, this one dealt with process servers, and I'm sure most of you are aware of the kerfuffle, for lack of a better term, that occurred around unlicensed process servers in Clark County, and this bill was primarily in response to that. And it indicates that an unlicensed process server who gets a cease and desist order can't serve. Process, if served by an unlicensed process server, it is not considered legally served. And there are new requirements for contents of proof of service. So you need, if you're going to be looking at this area, you're going to need to read the specifics of AB 156 to make sure that proof of service has all those new requirements in it.
John, a question that somebody might ask, if you know, it's a one-shot service of somebody by a friend or something, that is probably not what this is aimed at.
No, those provisions, I think, were left alone. This was more to a person representing themselves as a process server and representing themselves as a process server professionally. AB 194, this bill clarifies that courts have to pay for interpreters for persons with hearing disabilities in civil proceedings. This updates Nevada statute with current federal requirements, and actually, hopefully, we're going to be coming out here in a related note with a bench card about interpreter services for judges in the state, and you can go ahead and look for that from the Court Interpreters Program, hopefully in the near future.
Just as an aside, which was discussed, John, at the a meeting of the council last week, the federal requirements on paying for interpreters is very, very all-inclusive, and it's not new. Been around since 2002.
And that guidance, or the way the DOJ interprets that, requires that it doesn't deal only with persons with hearing disabilities, but deals with limited English proficiency folks, and requires that the court theoretically pay for all criminal, all civil, and all court-related proceedings. Yeah. So that obviously is kind of a question that's up in the air right now, and I'm sure many folks are thinking about. AB 196, this bill deals with some attempts to actually collect fines and fees ordered by the district courts upon felons and gross misdemeanors. It requires that the district court forward information necessary to collect the fine, and there's 5 things identified specifically in the bill that qualify as that information necessary to collect. needs to forward that to the county office designated to make collection, so that county office can go ahead and try to make that collection.
John, this was an effort that developed over a couple of years, showing that there were really millions and millions of dollars that no effort was being made to collect. This was not a threatening type legislation, but was authorizing legislation. And hopefully over the next year or so, efforts can be made to collect some of this money. Also added onto this then was a provision from the Comptroller's office for really probably some of the smaller local governments to contract with the Comptroller's office for a consolidated debt collection as well.
And this also gives counties an option after the county offices tried to collect and if they've been unsuccessful to go ahead and forward that debt to the state controller and let them try to collect, being that they have kind of a big existing apparatus and a fairly extensive statutory framework in Chapter 353C. AB 250. This bill makes permanent the police officer, law enforcement officer exemption from grand jury or jury service. AB 259, this bill is related to AB 65 of the 2009 session, and it diverts $10 of the filing and answers that were increased in that AB 65 bill on civil matters in district court to fund legal services in counties with a population over 100,000. So, and in counties under 100,000, that money or that money and the discretion to fund is left with the judges. It's expanded to include legal services. This also diverts $5 of the $50 notice of default fee that currently funds the foreclosure mediation program to programs of legal services, and these programs of legal services are those identified in Chapter 19. Ben?
John, yeah, this is watch this again. We'll see where these fees go, and if there's any effort in the next session to broaden this. But keep track of that for us too. With regard to the next matter that was interesting, this came from the courts also, was the grand jury selection process, and strictly a procedural, but to make it actually cost less and more beneficial to the county that have grand juries to select grand jurors. And the interesting thing that we discovered, the whole process was supposed to be carried out by the sheriff's office, which was a complete shock to them. So it was the responsibility for getting the grand juries together was shifted to the courts, but with an expanded pool to work with.
And it also, in that statute, if I remember correctly, there are several thresholds for number of potential jurors you need, and this bill tweaks some of those to make it more likely that a district court in Clark or Washoe County can actually impanel a grand jury. Senate Bill 6, this bill deals with electronic sealing of court records, and it authorizes the electronic reproduction of the seal of a court as another method by which the seal can be affixed to an official document. If you're going to use electronic sealing, the seal has to be reproduced in accordance with certain local court rules and rules adopted by the Supreme Court. This seal has the same legal effect. And there was some misunderstanding when we were talking about this bill that we're just going to put a picture of the seal on a document, and that's not necessarily what this means. The National Center for State Courts is a great resource in this area. They have a lot of stuff on reverse URL tracking and permissions and things I don't necessarily understand. But if you're interested in looking at electronic sealing, you definitely probably want to get in touch with them and talk to them about it, as they have a kind of a wealth of experience.
John, take 24, and then I want to comment after you tell them what it really does.
Senate Bill 24, signing of writs of execution. This allows a court clerk, under the supervision of a judge, to sign a writ of execution or renew a writ of execution. That's all it does.
That's all it does, but this was a piece of legislation that really would seem so simple, but when it was demonstrated that in district court,
Yes.
a clerk could execute a very, very significant writ. The legislators, and this is where if you can do something without coming to the legislature, you're really better off, because we had to backpedal like a son of a gun to make sure that they didn't take away the authority for the clerks to do it in district court. You know, and of course we worked it out, but it's just interesting how once you get to the legislature, once you open a chapter up, you never know where it's going to go.
And particularly even with a measure like this, that it's simply done out of practicality, because in our larger urban jurisdictions, you know, the counties would be paying some pretty serious workers' comp claims for hand surgery for judges from signing all these things. AB 195, electronic records retention. This is a bill that that was my favorite bill this session. It became kind of a big deal, but basically it does one thing. It allows the district court to retain records electronically in addition to retaining them as kind of an and/or thing with microfilm. There was another provision on this bill that dealt with the State Library and Archives, and the left hand and the right hand at the archives weren't necessarily talking to each other, and it ended up with a multi-million-dollar fiscal note. And we finally got it figured out at not necessarily the 11th, maybe the 9th hour of the session, and the district courts are now authorized to save records electronically.
John, is this the one where the Fallon newspaper said you were in favor of throwing out all DUI convictions?
This was the bill that was reported in the Associated Press that I was advocating that justice courts not keep any records at all. So where that originated is that this was going to change the requirements around justice court record retention from the current standards to make it in perpetuity, which obviously isn't doable based upon the number of tickets, etc. So I was presenting an amendment to fix that, and that got translated in the Associated Press, so worldwide, as I didn't think justice courts needed to keep records. AB 249, this is a bill dealing with court reporters. It makes some technical changes regarding court reporters in district court. This requires that people who transcribe court recordings must swear an oath that the transcript is accurate. Operators of court recording systems must swear an oath that the recording is accurate. So basically, there was some concern with this, but basically what that means is the person who operates the system presses on and off, occasionally checks to make sure that the recording system works. The deposit for preparation of the transcription in justice court is made with the court reporter, not the court now. And justice court recordings have to be saved for 1 year, and this is the audio recording or the visual recording. And in criminal matters, they have to be saved for 8 years. This was the major piece of legislation dealing with court reporters this session, and the court and its records commission are currently looking at making some tweaks to that through Supreme Court rule. The next bill we have up is AB 121. And this bill deals with exclusively Supreme Court security. It doesn't touch the district or justice or municipal courts. It allows the Supreme Court to appoint and employ Supreme Court police officers who are Category 1 peace officers. Currently, the Supreme Court doesn't have any authority to do that and has to rely on Capitol Police for security. It lets the Supreme Court also hire security contractors, so theoretically security guards to check metal detectors or something of the like. And this also expands the authority of Capitol Police to accompany the justices off-site. And this works hand in hand with another bill that was passed this session, Senate Bill 45, which clarifies and makes certain that Capitol Police officers are Category 1 peace officers.
The fun thing when we got to working on this, John, I believe that it was $50 a month. The sheriff from Carson City.
Yeah, there was a statutory provision that the Supreme Court could compel the sheriff of Carson City to be its bailiff and provide its security for $50 a month. While we had that statute open, we took that one out, being it's utterly impractical at this point. The next bill we have is Senate Bill 25, and this was a fairly contentious bill this session. It redefines the way that new justices of the peace are added in Clark County.
Again, very narrowly defined to Clark County. Now, the initial concern was because of the population triggers that you find throughout the revised statutes, all of course which are constitutional, but the every 10-year population change had not occurred yet. Next one, John will talk about that, will be in 2021. John and I'll be here. By then he'll have a white mustache and I won't have any. But this protects those that are in office now, increases the trigger for the elevation for another court, but this deals with Clark County only.
And those population thresholds are in AB 545, and so you kind of have to look at this bill, Senate Bill 25, and AB 545 in concert. Senate Bill 94 creates a new 10th judicial district in the state of Nevada out of Churchill County. This separates the current 3rd judicial district. The one judge currently based in Churchill County becomes the new judge for the 10th, and the two based in Lyon County stay in Lyon County, and it's its own 3rd, and Churchill's the 10th. This was the 3rd year this came up, and this time it dealt only with Churchill County. It didn't include Mineral County or any part of the 5th in its discussions, and it passed pretty quickly this session.
Just along similar lines with regard to legislation that deals with one particular area, John, in your miscellaneous section on page 88 of your summary, you've got the district attorney's office in Esmeralda County discussed, which was kind of interesting.
And that bill started out as applying only to Esmeralda County, but I think it eventually got expanded to include maybe Eureka County too.
Basically, it says the district attorney is supposed to come to work.
Yeah, there were some interesting hearings in front of the Government Affairs Committees on that one. The next section of the book we're going to look at is juvenile. We've only got a few bills here. AB 134. This bill brings Nevada law into compliance with the federal Supreme Court decision in Graham versus Florida that indicates that juvenile cannot be sentenced to life without possibility of parole for a non-homicide crime. And SB 112 makes some changes regarding records in juvenile court, and it allows better sharing of records between the juvenile court and the agency for child welfare that may have custody of the child. The last section we're going to look at here in our 2011 legislative review, I titled broadly NRS because this deals with statutes mostly. One bill in here makes some technical changes to statute. One makes some technical changes to the funding of the Judicial College that are indeed technical. We double checked a few times during session on that. But the major one here is Assembly Bill 545, and this is the Omnibus Population Threshold Bill. And as you know, there are a number of provisions throughout NRS that are triggered or changed by population. So counties over a certain amount have to do something that counties under a certain amount don't have to do, etc. And so that has to be changed every 10 years based on the U.S. Census, obviously. And so that's the change this time. And not to belabor this bill or go into it in any depth, if you look at page 97 of your legislative review book, you'll see that we prepared kind of an index to the important sections or the sections that impact the judiciary in this bill. So you can just turn to that and skip through and get the pertinent sections from the 294 pages, I think, of this one. And it's also got a little chart on page 97 in that legislative review book again that shows you what the population thresholds changed from. For example, 400,000, it used to be 400,000, it's now 700,000 to reflect the growth.
What's interesting, John, in the some 30 years of census that I've watched and these bills changing this threshold, nothing substantive ever got added to these until this session. And we had substantive matters all over the place, dealing with court security and personnel security, primarily out of Washoe.
But yeah, Washoe County.
Which really created some interesting maneuvering, but ultimately it got put back into just a technical correction to basically keep things as they are, except with the population increases.
And that's the extent of the bills we've drilled down into for you this session. And again, I'd remind you that there's more bills than we've covered reflected in the legislative review book that you're looking at. And also, if there's other bills, like maybe dealing with common interest communities that you're interested in, that we didn't cover in depth, always remember to check out the legislature's website. It's a wealth of information. They do a great job. And also, in your legislative review book, you'll find a link to that website and a link to a number of other interesting or useful websites, and my contact information if you have questions, starting on page 93.
And please, 2013 sounds like a long, long way away. But if you have legislative issues, and I hope that you don't, because it's better if we don't, but if you do, now is the time to bring them up and to start working it out, and let John and I know, and we'll help in any way we can to formulate a process that you can get your needs addressed. Okay?
Yep, and with that, we thank you for taking the time to watch.
Thank you.